Egg news. The Fifth Circuit ruling on marijuana users' rights. Second Amendment rights case just came out of the Fifth Circuit Court of Appeals, and it recently handed down this decision in the case of the United States versus Paula Connolly, a case that has major implications for the intersection of cannabis legalization and your Second Amendment rights. This case delves into the constitutional challenges against laws that restrict firearm possession by individuals who use controlled substances, in our case, marijuana, which remains illegal under federal law despite being decriminalized or legalized in various states and under the current rescheduling process federally. Let's do a case background on this and talk about the clash of your rights and the regulations. In December 2021, El Paso police responded to a shots fired at Paula Connolly's home. Upon arrival, officers encountered Connolly's husband, John, who was firing a shotgun at his neighbor's door. After his arrest, a sweep of the Connolly home revealed drug paraphernalia and several firearms. Paula admitted to occasionally using marijuana to aid sleep and manage her anxiety. This led to her being charged under 18 U.S.C. 922 G3 for possessing firearms as an unlawful user of a controlled substance, and under 18 U.S.C. 922 D3 for providing firearms to an unlawful user. And of course, this sets up our legal battle, the Second Amendment versus federal gun laws. Paula Connolly challenged these charges, arguing that these statutes were unconstitutional under the Second Amendment, both on their face and as applied to her specific situation. The district court sided with Connolly on her as-applied challenge, stating while there might be historical support for limiting the right to bear arms for individuals who are currently intoxicated, there is no such tradition for disarming sober individuals based on their past drug use. The government appealed, bringing the case to the Fifth Circuit, which had to consider whether the application of these laws to Connolly was consistent with the historical understanding of the right to bear arms, which is among the fundamental rights necessary to our system of ordered liberty. The Fifth Circuit issued a nuanced ruling. The court affirmed that 18 U.S.C. 922 D3 was unconstitutional as applied to Paula Connolly, because they recognized that while the government can restrict firearm possession for those who are actively under the influence, it cannot extend this prohibition to individuals who are sober and only occasionally use substances like marijuana. The court emphasized the historical tradition of firearm regulation and that it does not support disarming sober individuals based solely on past drug use. However, the court did not strike down the law entirely. It reversed the district court's ruling on the facial challenge, stating that there are indeed scenarios where the law could be constitutionally applied, specifically in cases where a person is actively intoxicated while possessing a firearm. The court used a two-part process to analyze her Second Amendment challenge. First, the court asked if the plain text of the Second Amendment covers individual conduct. Second, the court asked if the challenge regulation is consistent with our principles that underpin the regulatory tradition. The court easily answered the first question because the Second Amendment's right to bear arms belongs to the people, and Paula is one of the people. It means all members of our political community, not an unspecified subset. As a result, she has a presumptive right to bear arms, so the court moved to the second step to see if history and tradition support it. The state argued three historical examples of limiting a person's right to bear arms. 1, laws disarming the mentally ill. 2, laws disarming dangerous individuals. And 3rd, intoxication laws. The court found that the mental illness component was completely irrelevant to the case, as Paula was of sound mind. Similarly, the court found the nation's history of not allowing people while drunk to have guns, but allowing them to get them back once sober, underpinned the intoxication argument. The court found Paula more like the sober person that used to be intoxicated, but is still allowed to possess firearms once sober. The court also dismissed the idea that cannabis use makes someone dangerous and explained that our history and tradition of disarming dangerous persons does not include nonviolent marijuana users like Paula. Indeed, not one piece of historical evidence suggests that at the time they ratified the Second Amendment, the founders authorized Congress to disarm anyone it deemed dangerous. The implications of the ruling underscores the ongoing tensions between federal firearms laws and the evolving landscape of state-level drug legalization. It also highlights the judiciary's role in balancing individual rights against public safety concerns. For marijuana users who own firearms, this decision is very significant. It suggests that while occasional non-impairing use of marijuana might not strip away Second Amendment rights, the context and timing of the drug use in relation to firearm possession are the critical factors. Just like a person, while drunk, can have the right to bear arms limited, so too could the marijuana user under the influence. Moreover, this case could pave the way for further challenges to federal firearm prohibitions for marijuana. For example, that form you have to fill out when you purchase the gun and asks if you use drugs. The test of whether you are actively on the drug at the time appears to be the actual law and not just the full ban of the activity as Section 922G3 mandates. In conclusion, the Fifth Circuit's ruling in the United States v. Paula Connolly marks a pivotal moment in the ongoing dialogue about gun rights and cannabis legalization in America. By affirming Connelly's as-applied challenge, the court has signaled that the Second Amendment protections cannot be overridden lightly, especially when the individual in question is not actively under the influence of a controlled substance. However, the court also mandated that certain applications of 18 U.S.C. 922b3 and d3 remain valid, keeping the door open for these laws to be enforced in specific circumstances. For example, being armed while drinking or using cannabis. As the legal landscape continues to evolve, it's more important than ever for gun owners, lawmakers, and legal professionals to stay informed about how these developments impact the intersection of drug use and the right to bear arms. If you found this content helpful, don't forget to subscribe to our channel, give us a like, and tune into our podcast every Sunday for more insightful discussions. Stay connected and stay informed, everybody.